Welcome. Welcome here to the Institute of Advanced Legal Studies. Welcome to this lunchtime seminar. My name's Jules Winterton. I'm director here. And this is one of a series of lunchtime seminars that we hold most weeks. And they are designed to enable our visiting fellows to share their research. It is my great pleasure to introduce Dr. Okoye, who's from Canterbury Christchurch University, and she's going to talk about corporate social responsibility. And in fact, the title, well, you can see the title's right there. And over to you.
Thank you very much for coming. And I know I appreciate it's a windy day, and there are many other things people could have been doing. But I would love this opportunity to discuss ideas with you that I'm currently working on, and to leave room for questions that may help decide what direction this goes in the future. The talk itself is mainly a theoretical one, so there will be some reference to perhaps a few statutes and case law, but it's mainly a theoretical one, looking at the question of legitimacy of corporations, and specifically focusing on a work by James Willard Hurst in the 1970s, where he looked at the question of the legitimacy of corporations in the US, but in that work identified themes that cut across at least Anglo-American company law. So it is to look at that question in the context of what we now have as our CSR debate, and that's corporate social responsibility debate, and ongoing questions about the corporate objective and what the corporation should do. To start off, I don't expect to talk for too long. I hope maybe 20 minutes, 25 minutes, 30. But I do have some slides, and it's just to help delineate what I'm talking about. So I start off with my slides, looking at the word legitimacy. I guess so much of your legal training prepares you to define whatever terms you use when you're speaking, but legitimacy again is one of those contested concepts that also has various perspectives. So commonly when we talk about legitimacy, you will find that you could be talking about legal legitimacy, you could be talking about sociological legitimacy or moral legitimacy. It's often grouped in various ways, but I have taken this particular one from a work by Fallon in the Harvard Law Review, because I think it captures the essence of what we're trying to say. So when we talk about legal legitimacy, of course, we're talking about conforming to the law, conforming to whatever rules and standards are appropriate in society. But that in itself is not enough, because legal legitimacy sometimes could mask just legality and not legitimacy itself. So underneath that is often the sociological type of legitimacy, the type of legitimacy you hear Weber referring to when he talks about people's belief in something being legitimate. And so in that you're talking about legitimacy that comes from consent, popular consent, legitimacy that comes from acceptance. But that again is just one piece of the jigsaw, because something could be popular and, in a sense, socially legitimate, but not legally legitimate or even morally legitimate. So again, the third aspect would be moral legitimacy, where you're looking at this deriving from norms or standards or ethics, in the sense of, some people would say, human rights or a sense of justice. So how does it all come together? And what sort of legitimacy am I then talking about? I would use the interrelated definition, which is looking that a relationship is legitimate because it's not only justified in terms of people's beliefs, but that belief is based on normative standards which are embodied in law. So that's the type of legitimacy I'm looking at. But then how does this go for corporate legitimacy? So these are some of the questions you come across in literature. So I've picked just 3 of some of the key questions that seem to be coming up through different sorts of writings. The first one, he writes from the world of business, and he then asks regarding managers and the corporate executives, who selected these men, if not to rule over us, at least to exercise vast authority, and to whom are they responsible? So a question of whether these group of corporate executives or company leaders have any responsibility, to whom, how, and why do they exercise such power? That instantly draws up themes of power. For the second one, this is Mary Stokes. She writes that if private property is to be legitimate within the framework of liberal society, it needs to show that it has constraints. So again, conformity with rules. It needs to show that it has constraints which prevent it from becoming a source of power which threatens liberty. But also, it also will be such that it will not threaten the liberty of the individual or the power of the state. Then the third one talks about where power is deemed to be exercised legitimately, it has to be deployed within dominant rules. So for me then, what I derive from this is that the issue of legitimacy in company law keeps reoccurring for 2 key reasons. The first one is perceptions of corporate power. So the notions of capacity or exercise of corporate power. The question of the capitalist society here in the United Kingdom or the US and globally through multinational corporations exercising and wielding quite a lot of power, as well as having the capacity to affect decisions that people make in various key sectors in a pervasive way. And one of the issues about corporate power is when this capacity is exercised, for whom is it exercised on behalf of? So the question of are they acting on behalf of just shareholder interests, or are they acting on behalf of profit, which then will yield to some form of utility that spirals into society? So for whom? Then the second reason why legitimacy is an issue is the question of corporate objective. What is the function of a corporation? This is a question that has occupied writers for quite a while, and we're still not settled on the corporate objective. What we find is, of course, the dominant narrative that the corporate objective is profit for itself, profit for its shareholders, and society benefiting through profit that comes through taxation and the general well-being of these companies. But there are other narratives that drive and question whether corporations should not exist for stakeholders, for society itself. So these sorts of questions, what function, on whose behalf, go to also the issue of justification and legitimacy. Okay, so this just specifies a bit more about the questions we've been going through on corporate power, and the 2 main points I'd raised on corporate power and corporate objective. I just want to briefly say, of course, power is also something that people would contest. When I say corporate power is an issue, certain people feel it is more perceived than real. But what I wanted to point out is that it is especially the question of corporations being able to influence some of our basic social needs. So the production, credit, knowledge, security, the issue that all this is bounded in different ways with privatization of even public goods. You find that the influence, the sphere of influence of what would be a private entity has widened. And so corporate power is more an issue than it would have been perhaps a few centuries back. So again, this just says power in itself is value neutral. So power, saying that corporations have power is not equal to accusing them or saying, oh, such power means they are bad or good, because power can enhance the ability of any organization to actually do more good, as well as enhance the ability of that organization to affect people in a negative way. So it's not just mere possession of power that is the issue. The issue is often that you need to have constraints, you need to have justification in a way that that power should be responsible. So when we say someone has power, we are in a way assigning responsibility. In that sense, we need to be sure that such power is justified and that there are limitations. And that justification is the legitimacy question. A brief word on corporate objective. There is a link between theories of the corporation and the question of the corporate objective. This is, again, another huge area, but I would just say a few words. A lot of this shareholder primacy objective, which is the dominant narrative, dwells on the notion of companies being seen as contractual objects. So the notion that a corporate structure is a set of contracts. That has made it such that the contracts exist between members, and the members are the ones to whom ultimately the company should answer. And that theory has justified the approach which is dominant in the current Companies Act. However, there are other narratives. So we find that you can view companies as social institutions. This is something that Paddy Ireland argues for, where he traces the history of company law back to its partnership type origins and says the current form of large companies is very different from what we had in the past. And in a sense, the Bell and Means debate would mean that if they are so large that they are not essentially run for the members, you may have the notion where society should intervene and have other stakeholders figure in the configuration of the company. So let me quickly go on to Hurst. So why do I find him so interesting? Hurst is viewed as the father of American legal history. He influenced some of the great writers we know. Howes, who wrote Transformations of American Law. He influenced Lawrence Friedman. He wrote essentially about issues not just in private law, but looking at them through a legal historical lens, as well as a law and society mix. So he gave this lecture, which was eventually turned into a book, on the legitimacy of business corporations in the law of the United States. And within that book, he focused in his second chapter on legitimacy in a way that I think is still very unique. He did it simply, but made very strong persuasive arguments that have relevance today, but which remain unanswered. So in the second chapter, he gives his definition for legitimacy and gives an argument for why legitimacy should be the concern of any body of law. So he makes the very broad statement that what law permits or accepts, what it enforces or compels, should be socially useful and socially responsible. So he gives two broad headings to what legitimacy should do within a body of law. So legitimacy of corporate law, as they call it in the US, company law as we call it here, should be that company law itself should permit the corporate structure because it is both socially useful and also socially responsible. But he goes beyond that. So he uses analogy of US history, but incredibly as well, he mentions the English history, but I've done also some other research to sort of demonstrate what he's trying to say. So utility is such that the emphasis should be that there should be a pragmatism about company law. It should have a usefulness, and the usefulness should be such that makes it that it's not an end to itself. So the company should be useful, not just to itself, but beyond, to wider society. Utilitarian type perspective. So utility. Then as well, it should be responsible. And he defines responsibility as this, that legitimacy means responsibility is that the institution with power must be accountable to some judgments other than that of its power holders. So it introduces the element of accountability. So utility and responsibility as two pillars of legitimacy within company law. He then traces some historical steps. And before he does the US one, I want to point out some of the things he said about England and some of the things I found out as well. So he pointed out, of course, the pre-18th century authority of the king in Parliament to create a corporation, the grant and chartered style corporations. He pointed out as well the Bubble Act of 1719, which covered a period. This act was only repealed in 1825. And there you find that the act tried to discourage what was then unincorporated associations carrying on a business. And for a while, people then had to use ingenious methods through deeds of settlement in trust and pool together resources in order to form what was then recognized by the courts of equity. These deeds of settlement are important because it introduces the notion of contracts, the notion of people being able to, outside of statutory authority, create an agreement which can be enforced by law that allows them carry on a relationship of business. And this begins that trend of having contractual perceptions to company organization. And this aspect of partners being able to form essentially these deeds of settlement is carried through into the subsequent Companies Acts, which would be the 1844, and then the 1855 Limited Liability Act, which allowed the giving of limited liability to these associations. So what then happened is, sorry, I just need to move, is that when you have the 1855 Act, there's still quite a few restrictions by statute on how the business should be carried on. But by the time you come to the 1856 Act, you essentially have the view that business should be allowed to frame its organization, how it comes together on its own. So every man to employ his capital as he pleases, as long as the public is fully informed. So the 1856 Act sort of introduces a laissez-faire type analogy, which remains till today. Some of the leading historians would say, although the 1862 Act is regarded as the foundation of our current company law, the 1862 Act is actually a consolidation act of the 1856 and all the other amendments. He also then looks at the US. He makes some observations there about the dominance of the utilitarian perspective. So he notes the period 1880 to the 1930s. For those who look at it, you find this is the period running up to just as 1920s, you have the Depression, and that's when all the questions start coming. But up until that point, we were very, at least in the US, they were very concerned about utility, usefulness. How do we make, the law was concerned with structuring private power in a way that it is essential, that it makes the businessman's needs and desires most relevant. So it was the utilitarian perspective. With the Depression came questions about concern that utility on its own is insufficient. We needed to look at more than utility. For those who do company legal theory, they would also know that this is the time where you have the seminal debate between Bell and Dodd about what the corporate managers' relationship should be, who should they be trustees for, the responsibility questions for private power. And then he points out clearly that the rise of big business raises questions about legitimacy. So a lot of the structures you have within the typical Companies Act deal with legitimacy in a sense of first enshrining utility, profit making, which is central, but also it enshrines some accountability, but accountability usually to shareholders, investors, and then some outside regulation, but that regulation being for issues that fall outside of the sphere of the business director's discretion. So what we then have is the question that soon you find arising, that we focus quite heavily on utility. We also focus on internal legitimacy, so whether they are answerable to the internal shareholder structure, but there also began to be fresh questions on the external perspective. These questions arose mainly post the Depression, and it became questions established by the research by Bell and Means, which showed that within the large company, the notion of the active shareholder who supervises the manager is a myth, and that the shareholder should not then be accorded that sort of focus within a larger company. And the questions began to arise. What structures do we then have in place for making the managers answerable to this wider group that is now affected, which would include employers, which would include communities, it would include creditors? What sort of wider systems do we have? He concludes, like most writers at that time, by saying, oh, there's a bit coming up about corporate citizenship, it doesn't have a structure. I call it a now well-used criticism. The law added no defined standards or rules to spell out for what purposes or by what means management might properly make decisions other than in the interest of shareholders. So a default position of saying, we have no system to make them accountable to anyone other than shareholders, so this won't work. He even adopts that, and I don't blame him, because it's a very difficult question. So his work on its own is refreshing. It captures the debate in a way that is quite clear, and it's easy to understand. But it cannot stop there, because there are newer questions that have arisen. So these newer questions, I tried to capture a few of the questions to sort of help frame what we're talking about. So the first one says that different theoretical conceptions of the company have been intimately embroiled in the effort of company law to justify vesting the substantial power in corporate management. This was back to the question that if you see the company as a contract between its members, then the question of how you structure company law will be a question that deals with management and agency of management to shareholders. The second one is a broader argument, which is that there's a lot of arguments saying that questions of sustainable development, corporate social responsibility, wider issues, both triggered by the exercise of corporate power and affected by corporate power, should be integrated within the basic legal structure governing the formation and functioning of a business enterprise. It should not be an add-on. So, again, this is a newer question. The third question is the polar views between those who see company law as politically constructed, so therefore such that limited liability hasn't always existed. It is something that was brought in by legislation at a time it was deemed necessary that this be given to these group of people acting together in business, and that these concepts should not be hallowed. They should be subjected to analysis and, if possible, modified. And you would have people like Ireland in that group. And you will also have others like Hansman and Crackman, I wrote them as H and K, who talk about shareholder primacy being what we have and it works. Let's leave all other issues to do with other interests outside of company law entirely. So I know this is sort of a broad thing. There are more questions, but I think, again, it's relevant. So what do I draw from Hurst on this? That would be my... it seems that, and I don't think he's wrong, because I put in some of our sections to show where I think he's right. there is, in company law, an overwhelming focus on utility over responsibility. In fact, there are arguments that utility is a kind of responsibility, that if you focus on profit making, it is a very efficient way of actually achieving the one target than trying to focus on many other targets. So there's a focus on utility over responsibility. And where there are issues of responsibility, there's a focus on internal type responsibility over the external type responsibility. So company law review happened pre-2006. It started in the late 1990s, and they looked again at the question of what the corporate objective should be. The UK has been heralded as one of the most progressive company law reforms because it embodied what was called the enlightened shareholder value. But it did reject the pluralist approach. So it felt at that point that having a pluralist approach where you try to make management accountable for many stakeholders would diffuse accountability entirely. So it went for what was viewed as the enlightened shareholder value. What we find is that there's therefore been a reluctance to tackle wider social responsibility within company law. We're relying primarily on legal regulations outside the corporation's own constitutions to enforce other types of responsibility. One of the reasons for this may be because responsibility is more complex to try and factor in. So trying to work out responsibility to various interests is more difficult. So the reform had some aspects. So we had some reform with directors' duties, very popular, Section 172, but also a section which various academics have pointed out is quite loose. So I'll just read a bit of 172. A director of a company must act in the way he considers, in good faith, would be most likely to promote the success of the company for the benefit of its members as a whole, and in so doing, have regard to the likely consequences of any decision in the long term, the interests of company employees, the need to foster business relationships with suppliers, customers, and others, the impact of the company's operations on community and the environment, the desirability of a company maintaining a high reputation for high standards of business conduct, and the need to act fairly between members. So everything, everything's thrown in. But the key terms, in the way he considers, most likely, and then for the benefit of its members as a whole. So it doesn't move very far from shareholder primacy, and that's been settled. Also, it only gives, so for instance, we have derivative action. It is still the members who can enforce so many of the duties required of directors. So there is a privileging of members. And even within that ability to bring derivative claims, you find that this duty to promote the success of the company is a deciding factor on whether the application to continue the derivative claim will be allowed in court. So it means that company law still has a very limited focus on responsibility. It would enshrine issues of responsibility to shareholders, but externalizes all other types of responsibility to other areas of law. And what becomes the problem is that those other areas of law are quite diffused. So the responsibilities, health and safety, torts, you have different sorts of legislations, even criminal law, but all scattered. I asked the question, should it though? And this, of course, there's no firm answer, but I do raise two options. So there's one group that think there should be a radical reform of company law to make it a social institution. If you read the work of Hurst, it's not a new argument. We keep hitting the barrier of a workable organizational format for a company that answers to various stakeholders. The model we see in some civil law countries like Germany has been put forward, but then with the recent problems we have with VW, I'm sure there's also, but the question is that has a system where employees feature a bit more heavily, but it still doesn't cover the wide range we hear mentioned in section 172. So how will it handle suppliers, customers? How will it handle communities? How will it handle reputational issues? There is a second option, and that's one I am more interested in, which may be that it is right that some form of social responsibility is within company law, and we have it in section 172, directors' duties. We have it towards the shareholders, the minority protection, issues like that. But we may need to begin building a collective body of law focused on corporate social responsibility. And the question then becomes, what would be the legal framework for this area? Again, it would be a framework that tries to be less rigorous in terms of sort of procedural type format, but a theoretical framework that begins to conceive of responsibility of the corporation as one body of law. What I've been exploring is the possibility of using the basic leveling law jobs framework to discover legal and pseudo-legal type happenings in the area of responsibility and frame them around key themes of what the law can do. So issues of how you resolve disputes between the company and these other constituents, how you frame the relationship between the company and other stakeholders, and questions of the like. But it still remains such that we have these two options: a radical reform to incorporate the full responsibility within company law, and that involves a rethinking of our current structures. It's instructive to note that these current structures were political choices, they're political constructs, they're not inviolable, but they have worked and they've been very successful. So would you want to unravel that? Or do we, but there's still a need to have this responsibility in a focused way. And I would suggest that the second option of building a body of law focused on CSR is one that I think is more immediate and more necessary.